Hi everyone, we have Dr. Charu Mathur joining now.
So good evening. So today the case that we are going to discuss, if Pragya is able to join in between, it is fine. But otherwise, I'll take the session for you. So today the case that we are going to discuss is that of Shanti Conductors. Now this was a case which had come as a under the review jurisdiction of the Supreme Court. This was a case which was heard by three-judge bench of Justice Ashok Bhushan, Justice Nazir, and Justice Sinha. Now, this was a case, essentially, this was a case under the electricity rules and regarding the interest. And but what we are concerned in this case is what is the under which circumstances the review petition will lie. Right now, the review petitions, they were filed by the against a judgment which was given by the Supreme Court. And as you know, in the Supreme Court, review jurisdiction is there once the SLP is either dismissed or SLP is decided, right? A judgment is passed, and even if it is at the SLP stage, if it is a simpliciter dismissal, then also you can file. But generally, we file as a review petition after a judgment is pronounced. Now, as you know, there are various limited grounds for filing the review petition, and there is a period of 30 days within which a review petition is to be filed. Now, before I go into further detail, it is important that we know what are the facts of this case. So, in this case, the relevant electricity laws were concerned, and it was regarding the state of Assam. In the state of Assam, there was this Assam State Electricity Board. And in this case, this Assam State Electricity Board was the respondent. It has issued 2 supply orders to the petitioner. So petitioner in this case is Shanti Conductors, and there were other bunch of petitions as well. So in this case, the petition order was dated, they were issued 2 supply orders, and this supply was for the purpose of the supply of aluminium electrical conductors. So in this case, the petitioner company, it supplied this electrical aluminium electric conductors was supplied to the Assam Electricity Board pursuant to the supply order. Now, there was, whenever there is a supply order, it comes with the various terms and conditions. So, since this is by a state electricity board, so all these orders were in the name of the President of India. It provided that the President of India will provide for this payment of interest on delayed payment to small scale industries which were related to this. So if there was any interest that is to be paid for the delayed payment to small scale and ancillary industries, an ordinance was passed, and later it became an act, and which we will call the Act of 1993 in this case. Now, there was a writ petition which was filed by Assam Conductors Manufacturing Association, and the members of this Assam Conductors Association were Shanti Conductors was also one of the member of this Assam Conductors. Now, when they filed it, it was filed for the realization of the dues, and it was seeking payment. So an interim order was passed by Guwahati High Court, in which the High Court observed that respondent may settle the outstanding amount, and the respondent paid an amount of, that is your Assam State Electricity Board. It paid whatever was the amount which was due. So it was 2.15 crores in 1993, which they were supposed to pass. Now, this amount at that point of a time, see, now today we don't think that 2.15 crore is that big an amount, but in 1993 it was certainly a big amount, and so they started paying it in the installment, and the last installment was paid on 5/3/1994. Now, in this case, money suit, money suit, when it is filed, it has to be executed immediately because the sum is only to be certain. So once the money suit was passed in the Guwahati for a decree towards the interest only for the payment of the principal amount, and which had already been received. So the principal amount was received, and the only issue which was limited to the payment of the principal amount. Now, in this case, the trial court in the money suit, it asked the petitioner for to pay the further interest on the monthly basis. Now, against this judgment, there were appeals were filed, and finally, the matter came before the Supreme Court, and they said that whatever is the decision, whatever is the amount that is to be paid, it is to be paid, and they dismissed the appeal. So against this, there is this review petition. Now, what we have to look into the review petition is that there are very limited grounds. So one is there is an error apparent on the face of the record, or if it is such a glaring error that that it should have been pointed out, and even if there is one more thing that you need to remember is that review is for if there is only these kind of errors which are available on the record. But if it is merely for clarification or modification, then you have to file a necessary miscellaneous application for the same. But review can never be an appeal in disguise, right? Review, to it is only limited to the purpose that there is an error apparent on the face of record, or it is an act which was such that which was available to the naked eye. Now, in this case, this matter, see, review petition as far as Supreme Court is concerned, it is heard by circulations. By circulation, you mean that those judges who have heard it, it is not heard in the open court. They will go through your review petition, and then they decide that this is a case to be heard that they decided this is the case which requires to be heard in person, or this is a case which does not require anything. So review petition is by circulation only. So once a review petition is filed, in this case, they moved an application to be heard in open court. So this was a case which was heard in the open court, right? So in this case, one of the question which was framed in the suit was that whether the suit filed by the appellant, whether it is barred by the limitation. Now, this was a ground that they again raised uh, in the review petition also. But as you can see, the period of limitation, whether it is something which can only be discovered after the decision of the Supreme Court, or whether it was something which can be discovered even at the earlier stage. So in this case, this Shanti Conductors was led by Dr. Abhishek Manu Singhvi, and he said that there is an error apparent in the face of record in holding that suit was barred by time. So this was his contention in the review petition, that the suit was barred by the limitation was the contention which should have been decided. So in this case, Justice Dr. Singhvi took this that the admitted facts are that the last payment was made by the respondent on 5th March 1994, and suit having been filed within in 3 years, that is on 10 January 1997, was well within in time, and it was submitted by him that the last supply have been completed on 4th October 1993. And even though 3 year 3 years period from 4th. See, in these cases, these dates become important. 4th October 1993 has left. Limitation was available to the petitioner under Section 19 of the Limitation Act. Now, in this case, Dr. Singhvi, he further submitted that the petitioners were also entitled for benefit of Section 14 of the Limitation Act. Now, all these grounds he is raising in the review petition. Now, what was his submission was that these were errors which were apparent errors, and this need to be corrected. And in the light of the same, he said that in the light of the same, that any outstanding amount is to be paid. Now, as I have told you in the starting, that there was a 1993 Act which was providing for the interest. So, in this case, he sought to contend that 1993 Act is retroactive, and any further outstanding amount at the time of commencement ought to attract interest under the 1993. Now, as far as the state board, the Assam State Electricity Board was concerned, in this review petition, it was represented by Senior Counsel Mr. Hansaria, and he refuted the contention of Dr. Singhvi, and he held that there is no error apparent on the face of record. The question of limitation of the suit, he said that it was specifically considered, and High Court held that the suit is barred by time. So this was his contention, and he was going on that these are the things that it has not been available on the record. So Mr. Hansari, appearing for state board, he was able to show that as far as a period of limitation, etc., is concerned, that all these things, they have already been considered, and there is nothing which can be called as an error apparent on the face of the record. So, after hearing the contention of both the sides, the 3-judge bench, it said that they need to look into what does the Section 19 of the Limitation Act provides, right? So they went on to discuss Section 19 of the Limitation Act, and they found that in this particular case, it is governed by Article 113 of the Limitation Act, which is 3 years from the date when the right to sue occurs. So then they went to look into the High Court judgment as well as into the impugned judgment which was passed by the Supreme Court. And in this case, the 3-judge bench in the review petition held that the last supply was completed on 4th October 1993, and hence the amount was due from 4th November 1993, and the period of limitation would start running from 4th November 1993, and this suit was filed beyond a period of 3 years. So in this case, the court held that it is clearly provides that suit was filed, and all these grounds were already taken in the judgment which was made available to the party. So in this case, that the court also noted that there is no specific pleading by the plaintiff claiming any start of fresh period of limitation. So they said that there is the court said that plaintiff Shanti Conductors in the suit, they never said that there is any specific fresh period of limitation, and the court ultimately held that as far as this judgment is concerned, it provides that all these issues were taken care in the impugned judgment. So so in this case, the court relied upon, for the review petition, you have Order 47, Rule 1 of CPC, which provides that any statement, right, any judgment, it will be open to review if there is a mistake or an error apparent on the face of record. It has to be an error which is not self-evident and has to be detected by a process of reasoning, can hardly be said to be under review under Order 47, Rule 1 of CPC. So in this case, the Supreme Court, it clearly held that this is not a case where there is an error apparent on the face of record. And in this case, the review petition was ultimately being dismissed. So from the point of view of your examination, what is important is that you realize that as far as your review petition is concerned, it is only on the limited grounds, right? So in this case, like if they are raising the issue of, if they are raising the issue of limitation, right? It was, in this case, it was particularly being considered. Then if you take the issue of whenever you are talking about limitation, it was already been discussed. Here they raised a novel plea that it can be a continuous fault, and the court said that you never took that plea there and you cannot raise it for the very first time in the review petition. Thereafter, you have the cases. Thereafter, you have the cases where you have to show that it is such an error which was there on the record, but court overlooked it, and that has caused grave prejudice to the parties concerned. So only in those cases review petition will lie. So review petition in the review jurisdiction of Supreme Court is extremely narrow. It is a case, 99.9% review petitions are dismissed. Then you of course have a curative petitions are there. But even in the curative petition, the interference is even less, right? So when we will be doing Rupa Ashok Hurra decision, then we will be looking into these grounds. Now, when we are doing Shanti Conductors, we have seen it is on the civil side when the review petition will not lie. Then there is on the criminal side also, you can file a review petition. Now, there have been cases in criminal law where review petition has been allowed, like particularly in the cases where the parties have been discovered that they were juvenile, or this was something that it is causing a grave miscarriage of justice, that the court will interfere in the review petition. The recent case of the Supreme Court, which has created a lot of I'll say noise as far as relating to the murder. It was a case called Rahul versus State of NCT. So in this case, the Supreme Court, it let go the accused because it found that prosecution was defective, and this was a rape and murder case. So in this case, there was a review petition filed. Court heard it, and by a detailed judgment, they said that there is no scope of interference in this review petition. So from the point of view of your examination for your paper 1, you must know what is the review jurisdiction of the Supreme Court. And for paper 4, right, now for your leading cases paper, you must know the case laws like the Shanti Conductors, which dealt with the review petition. Now, if you have any other queries, if you have any queries, you can just ask me.
Madam?
Yeah, please go ahead.
Madam, once I had a glance at the judgment, there is a very little in the Supreme Court judgment about how a review petition is to be heard, what the grounds are. So how is it that this particular judgment turns out to be very important for review petition?
Right. So, I mean, that is even when this was put into the leading cases, I also had the same query that why this has become such an important case. Though, just like any other review case, it does not give you anything specific that, I mean, to my mind, making it a leading case. It is only it because in the case that it is in your syllabus that you have to read it. Like any other review petition, because this was heard in the open court, probably because the amount which was involved and the case laws which was concerned regarding the electricity law. See, if you look at the syllabus that they have put in the last 3 or 4 years for the AOR exam, they are giving equal importance to the commercial matters, right? And I mean, there are more important matters on the electricity law, but they chose to keep this as an important leading case. So I just like you, I also had the same query.
Thank you, madam. Thank you.
It's any other query, please? Dr. Hajim?
Yeah, I'm here. I'm here. I think, thank you.
It is a very small case
Yeah,
that we had
sure.
to. Yeah, if there is any other query, then I can just take it.
Yeah.
Madam, this is Advocate Gayatri from Hyderabad.
Yeah. Hi. Yeah, we met.
Yes, madam. Madam, in the examination, what to stress actually? Whether to stress in the section on the sections or whether to stress on the facts? Or no, you said about even the councils also, councils and the judges, and also what to be written and what not to be written.
Yeah. See, if it is
examination oriented.
See, this is a small judgment and does not cover, I mean, to my mind, anything substantial on the review law jurisdiction. So that is why I gave you about all the judges and all the lawyers, just to give you a background. But from the point of view of your examination, what we need to write is what is the concept of review. You need to remember the relevant provision. It will, because see, this is an open book exam for the leading case. So even section, etc., you will get the head notes. So if you can remember, that will be great. But if not, it will be there on the paper, in the resources which is supplied to you in the examination. Right. So you have to just understand the concept of review. You need to understand the ground on which the review petition will lie. Right. And then if you remember the facts of the case, that why this was not a case. So this was a case. It was not something new which was discovered in the review petition. It was something which was already there in the, which was already available, right? So in that case, you will say the review will not lie. Right, here they have taken the plea of suit was barred by limitation. See, the limitation period that you need to decide, that is the one of the earliest issue that you decide, jurisdiction and limitation, right? So this cannot be the ground of review after a decision has been given by the Supreme Court. You had gone, filed a petition in the High Court, then it has gone into division bench, and then in the Supreme Court. So for the first time, you cannot raise the issue that it is a continuous period of limitation will be a continuous one. So each day of not submitting the amount will continue as a continuous delay, and since there is no limitation period, so such grounds cannot be taken in the very beginning.
Do we need to specifically state about Section 19 of Limitation Act, or maybe whatever it is, like barred by limitation? And also,
yeah. So what is important in these cases is that you at least go through the head notes, right? Because otherwise it will be difficult for you to, if you have not gone through the head notes which are provided in the exam, it will be very difficult for you to write in the exam. See, we have got a limited time period of 3 hours to write, right? So it is a good idea if you can remember all these provisions, if you can remember the sections in the order, like order 47 rule 1, you can remember, that will be great.
That is enough.
Yeah.
Okay.
Do you have any other questions, or should we write that? Okay, I don't think we have more questions here, and thank you very much for joining. Thank you, Dr. Charu. So our sixth batch, just some more info on our course. Our sixth batch is starting on 20th April, and it will It will be till 3rd of June here. And so we have got 5 successful batches. Now, this is our 6th batch, and you can enroll till 19th April, and 20th April is the start date. And the course duration is 3 weeks plus 1 week of the revision classes. The classes will be in the evening, 6 to 8 p.m., alternate days. And just let us know in case you are keen to join. It explains all the 4 papers of the exam. And it not only discusses the eligibility criteria and preparation techniques, but also the examination pattern, tips and tricks for taking the exam. And this course will be taken by Dr. Charu Mathur herself. So just let us know in case you are interested in joining. And thank you very much for joining for today as well. Thank you, Dr. Charu. Thanks again.
Thank you. Thank you, everyone.